All right, let's get into this discussion now. Thousands face retrenchment as South Africa marks Workers' Day. Those thousands of jobs that are on the line in the mining sector, while the post office, for example, could also let a large number of people out of jobs. Let's speak about the rights of workers now with labour expert Galeboe Modisapodi and the business rescue practitioner, Nell, who joins us via the virtual platform. Gentlemen, to both of you, thank you very much for your time. Can I start with you, George? As a business rescue practitioner, you immediately step into the shoes of the executive management of a company that would have gone into trouble. How secure or vulnerable are the rights of workers at that company at the point of entry of business rescue practitioners?
Yes, good evening. The enactment of the Companies Act was by incident on the 1st of May 2011. So precisely 13 years ago, the Act was enacted in which I practice as a business rescue practitioner. The rights of workers are entrenched in the Labour Relations Act, and that is superior to the Companies Act in the case of a business rescue situation. So the situation with workers is precisely the same as before my appointment. But you must take into consideration that that company is in financial difficulties. That's why they are in business rescue, and possible retrenchment, liquidation, and job losses can occur in that situation.
Let's come to you, Mr. Modisapodi. With so many companies that are threatening retrenchment right now, what benefits are workers that are affected entitled to?
For a start, they're entitled to be consulted in the retrenchment process through their representatives. The Labour Relations specifically provides that there should be certain benefits that are the part of the discussions and the consultation. Retrenchment is a part of it. There will be arrangements around measures to mitigate the risk, which may include retraining to reposition employees for opportunities elsewhere. Right. So there's a number of benefits that the Labour Relations Act and other legislations provide that are there for the protection of employees.
All right, George, you have heard that particular input from a person who comes from a standpoint of employee rights. You've already said that the rights of workers are indeed superior, but we can't forget that the company is in financial trouble. And so the next question, therefore, has to do with whether or not these companies that get into financial trouble, do they in practice prioritize the rights of workers, or is it retrenchments and more retrenchments?
Well, in terms of the legislation, read with some of the court cases, the rights of workers is superior to the most things in business rescue. They've got a statutory preference above normal concurrent creditors. The business use the employee's time to make money, and for that, in South African context, it is a very important right. The legislation enacted, the business rescue legislation enacted in terms of the Companies Act, is specifically focused on job retention and try to avoid job losses. So, but in reality, we must be understanding that the company is financially distressed. Sometimes there could be negotiations, like my colleague mentioned, and that negotiations could end up in retrenchments. Once the company has lived through the business rescue, they can re-employ people. But on the other hand, if the business rescue is not successful, and remember that this is a company in financial distress, if the business rescue is not successful, the next step is liquidation, and in liquidation, the employees surely would lose their jobs if the company is not sold as a going concern within the parameters of liquidation.
Yeah, you've raced ahead because the liquidation part, I want to come to it at a later stage, but let's focus the attention on job retention. You would have heard Galeboe saying a little earlier that also retraining the workers in order for them to remain in employment, that also is something that ought to be considered. How feasible is this, given that the company concerned is in financial distress? Can this be done in practice?
That is a theoretical answer. In one sense, yes, it can be done, but the train is so quickly out of the station when you start a business rescue. You've got the creditors on your back. You've got everything going wrong in the company, electricity supply being cut and things like that. But one of the points in the business rescue legislation is that you must consult with the employees in developing of your business rescue plan. And I've published plans in which I have made mention of training and repositioning of employees. The UIF has got schemes in place, proper schemes in place. The main focus of the business rescue legislation is to save jobs, well, to save the company, and by saving the company, the jobs is being saved. Yeah. But it's a very short period of time that you have to publish a business rescue plan. Only 25 business days after your appointment, or such an extended period as allowed by the creditors, you can publish a plan. And that's a very short period of time to negotiate training and repositioning of employees. In practice, that will be a bit of a problem.
Yeah, and that's the point I actually wanted you to make. Galeboe, you have spoken about workers being given the opportunity to be consulted about what is about to happen, and if indeed there is the opportunity for them to remain in their jobs, perhaps reskilling comes into play. But as he says, in theory, that is what should happen. But in practice, it's a completely different story. So in the event that the workers do not get the benefits that are due to them, what legal options are available to these workers who are now effectively being retrenched?
I think my colleague has already said earlier that in the event that retrenchment cannot be avoided, there's a whole list of people who then lay claim to whatever is in the reserves or in the bank accounts of the company. And there's a priority, and in that priority, the first list will then go to employees in terms of their right to retrenchment packages. I think, as he said, the Companies Act provides that in the situation where you have a business rescue, there cannot be talk of retrenchments unless and until there is a business rescue plan in place. And only at that point can then the retrenchment consultation start. And when they do, the protection that's provided in the Labour Relations Act, and I think for large organizations, it will be Section 189A, they will then be applicable in regard of procedural and substantive fairness. So that's one leg of the protection for employees. But the other one is in terms of access to the funds that remain, in terms of distribution to the creditors and everybody. The employees will be first in the queue, and then where retrenchment is a key part of that, it will then be one of the first things that will have to be dealt with in terms of the disposal of the assets upon liquidation.
So we're talking severance packages? Severance
packages, yes.
All right. George, if the company cannot be saved, this is the element that you brought up a little earlier. It's now at liquidation phase. What does liquidation mean for workers and their benefits?
Liquidation is not a good thing for employees. It ends the employee agreement between the company and the employee. There's some technical comments I can make after so many days of the final appointment of the final liquidator and things like that. But the end result is the demise of the company, the deregistration in the end of the company. So then the workers will be in a worse off position than in a possible business rescue and the company being saved. Specifically in business rescue or in liquidations, there are a statutory preference there as well. In the Insolvency Act, Section 98A provides for some clauses like notice, leave pay, and retrenchment packages, but there's a limit to that, 12,500 to each class. So the total amount owed to the worker, for instance, if it's a 50,000, it will be limited to 32,000. But that's also in terms of a preference. So the problem is that the company is now in liquidation. All the assets are usually tied up under some kind of security bond or cession of book debts or general material bond or something else. And there's not, the business rescue has got a trade out possibility. In a liquidation, it's actually just a statutory instruction to the liquidator to sell all the assets and divide the income so derived in terms of a certain set of rules as per the Insolvency Act. And the first part of the waterfall will go to the secured creditors, and then only the workers, and after the workers, SARS, and then the concurrent creditors.
Yeah, okay. So I think that there's a bit of a contradiction there because my guest in studio, he talks about the workers being the first priority when liquidation comes into play, and then it is the creditors that are considered. But am I hearing you correctly when you say it is the creditors that are considered first and then the monies that are due to employees?
There's two classes of creditors mainly, that's secured creditors and unsecured creditors. And so the employee slots in between the secured creditors and the unsecured creditors as a so-called statutory preferent creditor. For instance, if there's a farm and the farm is bonded to the land bank, and the land bank has got 100 million rand bond on the farm, and the farm only sells for 90 million rand, there is a shortfall for the bond cancellation of land bank. So there won't be anything left in the so-called waterfall for the employees. But if that same farm is sold for 120 million rand, there's at least 20 million rand that will go down the waterfall, and the first instance will be the employees.
All right, if you're just joining us, you find us at the tail end of a discussion about that dark hour of retrenchment. When it does hit, how prepared are you? And, what are the rights that you are entitled to, including the benefits? And joining me for this conversation, we are still with Galeboe Modisapodi. He is an employee relations consultant at Mulatudi Advisory Services. We also have George Nell, a business rescue practitioner. So let's come back to you, Galeboe. Earlier, we spoke about this labor law expert who says companies should not be branded as evil when they retrench workers because they're fighting for survival, because they're also fighting to retain some jobs. Are workers cognizant of this reality?
Xoli, they are cognizant of it, but I think you also need to appreciate that there's quite a lot of emotions that are invested in that process.
Yes.
And one of the things that cloud the objective assessment of reality is what some may have perceived as corporate misbehavior by senior executives. I think the questions of pay parity may get into the scenario, obviously fueling emotions. So sometimes it's very difficult to explain to employees or even to union officials that the company is doing its damnedest to try mitigate the risk if at least not reduce the impact on employees.
Yeah.
So it's always in the process of the retrenchment consultation. But you can't take away the emotions from that exercise, because quite a lot of employees would have invested almost their lifetimes into the organizations. You have instances where some employees would have had 41 years of service.
Yeah.
And if we then get into a situation where there's a liquidation, they would have received quite sizable retrenchment packages, but for the liquidation itself. So obviously someone would want to blame somebody in terms of who was responsible for putting this situation where it is.
Yeah.
So emotions are really a part of it.
George, can I also put the same question to you, but slightly differently? What is the role of the Human Resource Department, particularly in consulting the workers about what's to happen, and also importantly, perhaps providing counseling services to these workers, because they are now going into a very uncertain period in their lives?
We used to, or still is doing in the business rescue, we appoint a counsellor, labour law specialist for the employees, because they cannot specifically afford the lawyer or a specialist in labour law to assist them. And hopefully that will make their plight a bit better. But since the start of this discussion, they're in a difficult position. On the one hand, you have a worker with 41 years of employment at the company, and his salary is now 12,000 Rand a month. And on the other hand, you've got the senior executive whose salary is R1 million a month. And it's difficult to explain to the workers that that person maybe must manage the company and so on. So there's a lot of emotions. You have to engage with your workforce through the union and through individual workforce, and you have to take them on the road with you. That's why I circle back to business rescues. That is the saving grace of companies, and I think it should be more frequently used by government, SARS, and big financial institutions.
Yeah. Galeboe, you are in the employee relations space. I want to put exactly the same question to you. HR, oftentimes there is a feeling that the HR department works in the best interests of the company and the senior management, much less to what the ordinary employee should be. Is that a fair way of looking at it, or am I completely missing the point?
That is not from my over 25 years of experience.
Yeah.
The HR department plays a critical role in terms of firstly balancing the power relations between the two from an advice point of view. But more importantly, when you relate that back to the culture of the organization in terms of its value and the value proposition it has, corporate social responsibility would dictate that the company takes a number of steps to mitigate that risk. So in the number of companies I've involved in across a number of industries, one of the key things that you need to focus on is how do you mitigate this impact for employees? Because one of the things that you have to take cognizance of is that because this exit from employment is very different from retirement, which many of them would have planned for, at least in their minds. There's a lot of turmoil that flows from that, and if they're not given counseling services, it then becomes very challenging. One of the instances I dealt with in my early career, for example, was when an employee had retired after 45 years of service. But the challenge he faced was that he didn't know how to wake up and not go to work. And part of the work that we needed to put in place as an HR department was how do we help him transition from work every day into retirement? Yeah. And the same principle would apply in regard to the retrenchment world. And a number of organizations will then do that in terms of making sure that part of the plans is to assist employees transition with what are called employee assistance programs. Yeah. So the role of HR is quite key in that process, not only in the consultation process itself, but how do you manage two groups of employees in the event that some are staying behind? Those who are going have social adjustments to make, and the same applies to those who are remaining, because they have lost their friends who have no jobs. They have to wake up every day, going to work and looking at their colleague who's not working anymore.
Yeah.
So all of those things have to be factored into the plan that HR should advise management to put together to then manage that process.
George, before we end the conversation, whilst on a break, you spoke about some kind of special fund that should be introduced to look after, I think, not only the company's resources, but to make sure that workers are also taken care of. Did I hear you correctly?
Yes, they call it a super preference. That is now over and above the secured creditor, some kind of super preference. I was involved in a mine. I think there was 15,000 employees, and they worked all over Lesotho, Swaziland, and the like. And then I realized if I can only have 1,000 rand per employee available, at the beginning of the liquidation, it was a liquidation matter. At the beginning of the liquidation, I could at least give them that amount, that super preferent amount, so that they can get some transport back home and so on. Otherwise, they were staying in the hostel and become unmanageable in the hostel because they didn't work and they were laid off in this liquidation process. So that's what I mean. I don't say they have to get all their money, but there must be some kind of super preferent fund, even by the UIF, to assist these people in any case where they do not get salaries.
Yeah. All right. Galeboe, any last words from you as we conclude this conversation?
I think the last word for me would be retrenchment is not an easy process to follow, both for employees as well as management. So everyone involved in the process, the more you take it to heart in terms of attaching emotions to it, the better the process of managing it, because the people that are involved are not just numbers. They are somebody's fathers and mothers and uncles, etc. So you're talking about the livelihood of people. So the more you attach your social conscience to it, the better the process in terms of managing it.
Galeboe Modisapodi, thank you very much for your time. Employee Relations Consultant at Molatudi Advisory Services. And we also had George Nell, a business rescue practitioner, joining us for this conversation. Thank you, George, for your contribution.